It is sometimes said that the law is applied logic. Obviously, this is epigrammatic statement as a foundation of truth. For the practice of law fundamentally argumentative. It deals with the subject in controversy and its primary aim is the settlement of dispute, sometimes by the persuasive method out of court and sometimes fiercely contested legal battles. In either instances that the instrument of reasoning playing a dominant part at the first of all initial sine qua non to the process of correct reasoning and argumentation in proposal of proposition. Argumentation is a process to determine the truth of falsity of some time relations. To do this successfully required that the particular relation to be set out carefully for the purpose. It must be clear single and alone. The only known method of securing such a result is the embody of relation in the formula of thought and languages. That is the affirm a given thing to belong to a given subject. This is known as a proposition or the outline of a mental operation. The proposition is peculiarly essential of law, since the very earliest attempt at judicial procedure in England recognized the necessity of the reducing a dispute to an issue which was defined to by a preposition affirmed on one side and denied on the other. Now the results sought by the process of argumentation are either to prove the truth or falsity of a given of preposition, or with less absoluteness to induce the mind to believe at least in its truth of falsity, or still less merely to accept the same of general principle. The first degree of impression constitute the effect of absolutely certain, second moral continuity, while the third amount of some degree and possibility only. The form of argument are therefore the method of adducing evidence and valuable not only giving system and order to compilation process, but also because they become means of discovering and disclosing of evidence otherwise overlooked. One of the most important forms in argument by deduction, deductive logic, is a mental operation by lawyer must employ many times a day. Deduction is a movement of a mind from an object as the whole to some point where there is a movement from the general to a particular to interfere from all to anyone included within the all. We are familiar with the axiom of or law of thought that the two things that are the equal to the same things are equal to each other. For example, if we now the relation of A to X and B to X, we can discover two relation of A to B. Here then are preliminary relation A to X and B to X, and thereupon the conclusion follows of the relation of A to B. Obviously, therefore, it is in making of interference. We will have three things to be related, three relation resulting the three preposition. The total arrangement of these things, relation and preposition, in order the so how to interference in thereby developed is called a syllogism. The arranged structure, whether it is to be composed of a single word or a words, a phrase, a clause, or a whole paragraph, in short, whatever taken necessary whole, in short, whether together necessary express complete idea of the thing related. When used, the syllogism is called a term. The first preposition because it contains the larger term in name of major premise, or literally the larger principle laid down. The second because it contains a smaller term is named the minor premise or the lesser statement laid down, while the third preposition because the follows from the major and minor premise in name of conclusion. The following typical syllogism will illustrate the simple idea. All men are mortal. The Socrates is a man, therefore the Socrates is mortal. There Three terms of Socrates, mortal and man. It is evident that the Socrates and mortal, the two terms brought to the conclusion, are the established in their relation by the means of third term in which both are related. This is the mechanism of the syllogism, a process which plays a large role of every argument before the court and jury, but which still fulfills a more conscious conspicuous function and its relation system of pleading. Bliss, in the authoritative work of the Code of Pleading, give several pages of discussion of the importance of syllogism in the relation to pleading, in which he says every statement in the fact constituting a cause of action or a defense is a part of a logical formula. The illustrated how to prove the above statement in the following will show how to succession of the issues rise the legal to illustrate how true the sum statement is the following will show how to succession the issues rise to legal controversies necessary to arrange themselves into the framework of a deductive syllogism. These suppose is an action of trespass upon the real property the plaintiff complaint having a look at general law governing trespass. We find the statute or common law to be substantive as follows. Complaint measure premises everyone to forcibly and against the owner will enter upon the lands another guilty of trespass and liable in damage, concluding the general rule over this rule hereby makes the pleading as follows. Minor premises and complaint. The defendant will plead upon a certain date, a certain place forcibly against the will of the owner enter upon the plaintiff land. It is a conclusion. Therefore, the plaintiff was injured and the damage the sum of X dollars. However, another way of saying that the defendant committed a trespass to damage to the plaintiff. Now, in the above statement, there is exposed a complete syllogism of which is the first preposition constitutes the major premise of the general rule of law. The second preposition constitutes the minor premise by the alleging a certain fact of come within the rule. The third preposition draws the conclusion which the judgment of the court may be afterwards affirm or deny. The plaintiff of complaint thus the express of major premise, the implications and minor premises by the direct allegation with the conclusion by the indirect allegation of damages and prayer for the judgment. Suppose that the defendant upon the inspection of the above complaint comes to the conclusion that the fact as the alleged do not come under the general rule of law. He thereupon raises the issue of law by demurring of ground that the complainant does not state the cause of action, what is called course of reasoning. Major premises any set of fact which does not come within the general rule of law governing such fact is not actionable. Minor premises and etc. This said fact does not come within the rule of law. Conclusion. Therefore, this said fact not actionable, but suppose again that the defendant finds that the alleged fact to do within the general rule of law, but that the so alleged facts are not true as alleged, consequently he decided to deny truthfulness and thus rises an issue of fact. The reasoning will run as follows. Major premise alleged fact which are not true constitute no cause of action. Minor premise the defendant denies each of every allegation plaintiff complaint equivalent to fact are not true. Conclusion. Therefore, there is no cause of action and action at law as a whole does not them merely constitute an analogy of syllogism, but is one the subject of all this rule of fallacies. Deductive logic is the science of reasoning from a general rule of particular instance and practices of law. Precisely application of general rule of law is a particular set of fact. Correct pleading is therefore but the little more than correct reasoning, and since the compelled by the nature of mind in follow certain immutable logical principle, the comprehensive knowledge and such the principle of it is dispensable. We have doubtless said enough to show the necessity of a knowledge of a logic for a lawyer in his work, where the must resort the argumentation as a regards the other topics treated in the logic. Their utility is no less clear. The concept we need clear, precise, ideas, etc., must be evident to the reflective mind. Variation of languages call the knowledge of the various form of the syllogism. Though the day of professed sophist in past, yet even the among lawyers there will be a wanting man who, for a consideration, will endeavor to make the weaker cause appear the better. Hence, the advantage of the study of common fallacies, the hidden violation of logical rules of principle which might deceive the unwary. The old fallacies of dilemma litigious may find the counterpart today. It is related that the Protagoras and sophists agreed to train the enthusiasts in the art of rhetoric, and condition being that only half of fee should be paid at the time. The payment of the remainder was the depend on the enthusiast's success. The first lawsuit should be fail. The fee was to be forfeited. In Aeschylus delayed the undertaking any suit, and eventually Protagoras himself summoned him before the court. He argued the following dilemma against him: if this case decided in favor, you must pay me by order of court. If it is decided in your favor, you must pay me under the term of our agreement. But it must be decided either in my favor or your favor. Therefore, you are any case bound to pay me. This argument made the Euthesus as follows: if the case is decided in favor of, I am free from your terms of agreement. If it is decided in my favor, I am free to order of the court. But I must either decide it in favor or any favor. Therefore, I am very case discharge of my debt. The old judges of Greece, we are told, left case undecided, but one who was studied logic of advantage, the fallacy of argument, both the constant and self-evident.